Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
Sounds good.
Okay, so now let's keep going down the shaft here. Whereas the chiefs might be getting the shaft, now let's go to the elevator shaft. I don't truly understand this case, and it doesn't justify a lot of discussion other than just to say what's happening. A woman is suing a Delaware fire department and some elevator maintenance people and others because she stepped into the elevator, it wasn't level, and she trips or hurts herself. It's a little tough to figure out exactly what happened, but she fell because the elevator floor is not level. I'm not sure why she's suing the department, other than I'm guessing they were there and they brought the elevator up or down and left it unlevel. Or do you understand this anymore?
Yeah, I think I do, but I mean, I got to speculate. Okay, so I'm drawing on my experience. But very typically, when we have an elevator emergency, and this is in a Holiday Inn Express, which I stayed in one last night. As a matter of fact, it's Salt Lake City. But they typically will have two elevators side by side. And so when elevator one is stuck, there's a problem with elevator one, very often we'll shut down both elevators, open the hoistway door on elevator two to access the ability to open the doors on elevator one. Okay, so you've opened the hoistway door. And I actually got a question on LinkedIn about this, like under what set of circumstances could the fire department be liable? So, and I'll throw it out to you as a plaintiff's attorney here. Not that you are a plaintiff's attorney, but
sometimes, but rarely, yeah.
Usually you don't sue fire departments, neither do I. But so you have a fire department shows up, elevator one is stalled, they shut down elevator one. Elevator two, they need to open the hoistway door for elevator two, they shut down elevator two, and they open the hoistway door. The clerk, the desk clerk, tells the people, don't use elevator one, elevator two is still operational, because to the best of that person's knowledge, it was just elevator one that stalled. So the fire department's up on the second or third floor or whatever. So the desk clerk doesn't know. And the firefighters are now working, getting the people out of elevator one, but the hoistway door to elevator two, for some reason, is still open, and in walks our plaintiff, and she, I don't know how far she fell. It doesn't sound like she fell that far, but once that hoistway door is open, and then even if they had closed the door, it could have been a couple of feet below, it could have ended up a couple of feet below. I think that's kind of a stretch there. So again, we don't know all the details, but they're alleging, that there was a problem. Now, the question I got on LinkedIn was pretty good. And, to me, it's really about the fact pattern. It's not so much the question had asked me, is there any precedence for holding a fire department liable? And I said, precedence isn't really an issue here. Yeah. It's the facts. And if the fire department had opened the hoistway door, or the fire department had caused the elevator car to be lower than what it should have been, then the fire department created the hazard. Right. And factually, they now have a duty of care if someone could be injured, because they did it. If the fire department's just on scene, and there just happens to coincidentally be another malfunction of another elevator, they're not responsible for that. They didn't cause that, and they don't have a duty to, make safe something that is existing in that building. So, interesting issue. Again, here we go speculating.
And there's no way to know. Look, and you could change the facts even more. Now, say it's an emergency. Somebody's having a medical emergency in that other elevator, so they can't focus on the one she tripped in. So they're dealing with an emergency. I mean, you could change the facts so many ways. But look, this is a basic negligence case, right? They probably had a duty to somebody, though maybe not, right? Public doctrine, duty doctrine, who knows? But if
Right, that's where the precedence could come in, because very often in a case like this, what the defense, the city's or the fire department's defense is going to be is like, even if we were negligent, number one, even if we had a duty,
right?
Number two, even if we breached that duty and were negligent, okay, we do not have liability because we've got statutory immunity, we've got sovereign immunity, we have some sort of immunity that is associated with carrying out a public function or whatever it may be. So there could be other precedential reasons why we don't even get to the merits of the case.
We just don't know enough about it.